Well, efforts by Deputy Chief Justice Philomena Mwilu to halt legal proceedings against her have hit a snag. This is after Chief Magistrate Lawrence Mugambi rejected the High Court order blocking Mwilu's charges. However, this rejection is based on a technicality with the submission of a wrong file. The developments today introduce a new twist to this saga. Intrigues that will be expounded on the big story tonight. Let's begin with this soundbite by Senior Counsel James Orengo, who spoke for the DCJ.
Now, Your Honor, the reason why we are making objections for the plea to be taken is that this prosecution has been brought for an extraneous purpose, the objective of which is not to achieve the aims of the criminal justice system, but secure the removal of the Deputy Chief Justice. And that predominant purpose has a collateral attack on the entire judiciary. That's why you're seeing so many senior counsels here today. So that we are going to demonstrate that these proceedings are not necessarily our prosecution against the Deputy Chief Justice, but it is an attack on the judiciary. The criminal justice system has been weaponized to achieve an external purpose and for an ulterior motive.
So on the big story tonight, we will speak with Murang'a Senator Irungu Kang'ata, who's yet to get here, and lawyer Steve Ogolla as well, who's in studio. FIDA has indicated their support for Mwilu, and tonight we will try to pick the minds of the gentlemen we will be having in studio. But before we get there, our lead reporter, Sophia Wanuna, is standing by with ODM Secretary General Edwin Sifuna, who issued a statement yesterday saying his party suspects there could be an ulterior motive in Mwilu's saga. Sophia.
Good evening, Linda. What a day it has been, legally speaking. Watching those proceedings at the Chief Magistrates Court earlier today. Of course, we saw that arguably legal, strong team representing the Deputy Chief Justice, led by lead counsel, senior counsel, if you like, James Orengo. We've just had him there speaking about this being an abuse of process, being a targeted effort at the DCJ. But as that process was ongoing, other counsels representing the DCJ were in the High Court, and this is on the question of jurisdiction, because we had the submissions made before the Chief Magistrate that particular court had no jurisdiction to hear this matter, and an order was obtained. And as jubilation was felt and seen within the camp of the DCJ, once that order landed in the courtroom, then the prosecution peeking out a technicality, an error in as far as case file number, and with that, the Chief Magistrate finding that then that stay order, as had been announced and indicated earlier, cannot be enacted or enforced because it was not clear, and that they cannot purport as a court he himself to interpret or imagine what the High Court Judge Chacha Mwita meant to say or guide the process. So they go back on Friday. They are free with that bond, personal bond of 5 million shillings. But in the meantime, as you mentioned, the Secretary General of the Orange Democratic Movement yesterday sent out that statement on one hand, lauding the efforts on fighting graft, but on the other, saying that there needs to be care taken in as far as how these issues are handled. Edwin Sifuna is with me tonight, and thank you for your time. So you appear in your statement to be reading ulterior motive, that this is part of the revisit President Kenyatta spoke about last year. But what specifically gives you that indication?
Thank you, Sophia. You appear to be the only person who actually understood the statement that we put out yesterday, because as you said, we first lauded the efforts to fight graft in the country. And we only sounded a word of caution, because everything that happens must be put in the context within which it is happening. Mm-hmm. The historical context of this particular matter is that there were certain pronouncements that were made by the then Jubilee candidate Uhuru Kenyatta that pointed and were interpreted by many of us to be a very active threat from somebody who was saying that immediately after the elections are done, he would revisit the judiciary essentially to take care of what he called problems within the judiciary at that particular point in time. So, of course, the country, with that historical context, we have questions to ask ourselves. And in our statement yesterday, we were only asking that the DPP assures the country that he has satisfied himself as to the requirements of Article 157 of the Constitution, which places a responsibility upon him to also ensure that in undertaking prosecutions, there is no abuse of the legal process. Yeah. And abuse of the legal process could come where the legal process is used to settle scores or to revisit, as was put by President Kenyatta.
And yet that question was put directly to the DPP when he was announcing, and he said, we are an independent office. This is not a move that's instigated or because of pronouncements made outside of it. Didn't that satisfy you?
Well, the fact that it came up immediately, that the announcement was made, is a pointer that Kenyans have this at the back of their minds. And that satisfaction also has to come from the nature of the charges that are brought. I have spoken to the lead counsel in this particular matter. Of course, I'm not part of the defense myself, but Senior Counsel Orengo is also a close friend of mine and somebody that I know. I've spoken to him, and in his own estimation, the charges that have been brought, and at least the evidence that he has seen so far, and the explanation that has been given to him by his client, suggests that really these particular charges may not hold. And at the end of the statement we issued yesterday, we reiterated we will not, as Kenyans, forgive the DPP if he does not secure a conviction in this particular matter, now that he has chosen to proceed in the manner that he has. Because in our view, honestly speaking, it is the entire institution of the judiciary that is now under scrutiny. And we had proposed, because we have seen in similar cases involving judges, including the former DCJ, that in fact the person was removed from the judiciary first as a member of the judiciary. Then at that particular point, we have opportunity for him to face the criminal process, justice system. So we would have preferred, and many people agree that it would actually have been neater for them to present whatever evidence they have before the JSC. And you know that the JSC, of course, even the threshold or the threshold for taking action, the burden of proof or the standard of proof is far much lower than the standard of proof in a criminal trial, which is beyond reasonable doubt, that if she had gone through that process at the JSC, and the JSC actually made recommendations to the president to form a tribunal, at that particular point she stands suspended, then really she's no longer part of the judiciary and they can take her through the criminal process.
Yeah, but herein lies the problem with the JSC route. One, she's a commissioner. She's a member, rather, of the Judicial Service Commission. Number two, right now 5 members of the commission are yet to be sworn in. So add her to that number, that makes 6, meaning the remaining members, who are 5, do not make quorum. So JSC as it stands is not an option. So then that is not untenable.
I understand that, but we can be able to sort out the issues of quorum at the JSC. For instance, if it is that of course she is a member of the JSC, but she's not going to sit on her own case. That is a known fact. Number 2, we have had a problem. Even the Law Society of Kenya has taken a position, and for us, I believe that it is a correct position, that in the instance of Justice Wasame, where there are some quarters that are insisting that he needs to be subjected to a parliamentary vetting, it is a clear attack on the independence of the judiciary, and it is something that need not happen in this particular instance. And I believe there has been a decision in that particular light by the court itself, by the Constitutional Court, that really the problems within the JSC in regards to quorum are artificial problems, and these are problems that need to be sorted out. They can be sorted out, and that cannot be used as the excuse for bringing the entire judiciary into all this, disrepute that has now attached to this particular case. Yeah.
And I imagine at the time you were sending out this statement, there was a green light given by the party leader Raila Odinga. Today we saw Honorable Kalonzo Musyoka, former vice president, in court. In fact, got opportunity to address the court. Yes. Will we see Raila Odinga when he returns, as depending on how this matter progresses, also showing solidarity in the manner Kalonzo did?
First of all, I must say that we are not going to parade our internal workings as to how we generate statements for the party. But one thing I want to remind people is that Sifuna does not speak for himself. I have a political party to speak for, and before a statement is arrived at in the manner in which it was, we do consult widely as possibly can be done, because it is not a position, it's not a personal position. I am
only the party leader consulted?
A mouthpiece, and that's what I've told you. I am not going to involve you in the internal workings of the generation. Do not ask me how the sausage was made, Sophia. This is a sausage. It has been made according to the political, the structure of a party and the constitution of a party. So if indeed, and you know that even within ODM, it is a big political party. Most of the decisions that we take as the national office of ODM, it is not always acceptable to everyone, because we are a democratic party. So there are people who have expressed different views, but at the end of the day, I can assure all the members of the party that this particular statement was processed through the channels of the party.
So are we likely to see him present again to show support for the deputy CJ?
Now, unfortunately, you would have to ask him or to wait for him to come. And he also has his own office at Capitol Hill that speak to matters that are personal to him, like the ones that you're asking. But for us as a party, him included, we have given a position.
And then those who are looking at this, you talked about perspective, this coming after those pronouncements that were made last year. There are those looking at the legal team representing the DCJ and say this paints and reminds them of the legal team representing the former Prime Minister in the presidential petition. Yes. And questions are, is it protecting the one who helped in that quote-unquote scenario? There are those kind of conversation and speculation around this kind of rallying around the DCJ. What do you say to that?
As I explained to your colleague Chris Tairu in the morning, first of all, these are the best brains in the country. And of course, this is a very high-profile matter. The DCJ is not a small person. I mean, this is somebody who has access to and is actually entitled to the best legal representation in the country. On the issue of whether indeed there was any relationship between the advocates who represented NASA in the petition and any member of the bench, legally, from a legal practice perspective, if indeed there is any suspicion of bias because of the various relationships that might exist, that particular issue has to be raised actively in the case that is before the bench. I don't recall any person during the hearing of a presidential petition raising an issue as to the relationship between any member of the NASA team and any member of the bench. So these are just perceptions, and you must understand.
Perceptions can be...
as I told your colleague in the morning, we cannot control perceptions. We cannot tell people what to think. We cannot tell people what to perceive. What I want to remind people is that if indeed we were doing this because she is one of us or that she supports us, there are people who are actually our own that have actually gone through this process, and you have not seen all this hula baloo. We have seen Governor Kidero, for instance, is somebody that is a very close friend of mine and a member of a party. We have seen the Busia Governor Ojamong also being arraigned in court on similar matters, but we have not seen the sort of reaction that you have seen from a party, because for us as a party, we are trying to shield the institution itself and not any particular individual, the institution of the judiciary.
You talk about them being the best brains in legal practice, and yet that legal, simple, if you like, has been argued, technicality skipped them. 32 lawyers, and it had to take the prosecution in a 10 seconds to throw that out there?
Let me tell you, Sophia, in this particular matters, in instances such as this, there's a lot of pressure, there's a lot of, there's a lot of things that are happening. And in fact, it is something that is such an easy oversight or mistake to make, because that number, the number that ended up in the order, is actually appears on the face of the charge sheet itself. The charge sheet usually has up to 3 numbers. There's the court file number, there is a police file number, and there's a number that is the criminal case number of the particular case. So it is very easy for somebody who's drafting the documents to be able to make that mistake. It is a
60 eyes looked at that report?
I don't think that 60 people can sit somewhere and draft. Of course,
the way 60 eyes, like 30 counsel representing.
But this is what I'm telling you, because I have been in a legal panel such as this before. Usually it is a bit compartmentalized. They'll say, okay, Sifuna, this is your work, you will do the application, somebody else will. At that particular moment in time, it is human to make mistakes such as those. And it's not a critical mistake that goes to the nature of the application. The legal reasoning is sound, the grounding is sound, but a clerical error is something that can be made in such instances.
Finally, before we take it back to studio, other judges, I think 2 or 3 I spoke about yesterday in our show, that had initially faced criminal prosecution and charges, at the time of the trial, did not continue to preside over cases because it would be untidy. Some have argued it's a moral question. Wouldn't you, you're not part of the council, but advise perhaps that now that this process has begun, that she take what we call step aside, take time off? Yeah,
that is now where the problems begin, Sophia, because there are those of us who think that is in fact what is the intention of all these so-called corruption charges. I have personally defended somebody who was charged with similar things. When Gladys Sholei was being hounded out of the judiciary, we had a similar experience, that even before people interrogate whether indeed the veracity of the charges and the weight of the evidence, people are already calling on you to step aside because essentially it is a moral thing to do. Where is the morality when you have not examined even whether these charges can hold? And we always believe and suspect that sometimes all that it takes in this country to tarnish somebody's name and to end somebody's career is to make the allegation. All you need to do is to make the allegation. You can imagine the situation that we are in with the DCJ now. She has not even taken plea, but people are already saying she needs to step aside. It is a bit strange. This is the part of the quagmire that we were trying to avoid, or would have been avoided, if the Director of Public Prosecution had chosen the path of first having the JSC interrogate these matters. Because when it comes to suspension of a judge, the matter of suspension of a judge is a matter that is dealt with exclusively by the Constitution. And it is a suspension, for instance, only happens upon the finding by the JSC that a tribunal needs to be formed, and the recommendation is made to the president, and at that particular point they proceed to be suspended and to earn half pay and all sorts of things. When you look at the Anti-Corruption Act, it also has provision for public servants who are charged with offences under the Economic Crimes Act and Anti-Corruption Act, that immediately you are charged, you are supposed to be on suspension and on half pay so that you are able to be outside of the institution. But you see, the regime that deals with the suspension of judges and the discipline of judges is separate from the Anti-Corruption and Economic Crimes Act. This is the problem that we find ourselves in. So how do you suspend a judge using this particular procedure, yet the procedure for their suspension is a constitutional procedure? That is, those are some of the constitutional difficulties that we're going to find ourselves in because of the path that the DPP has chosen. I personally believe that we could still have achieved, especially because of the high office in that the DCJ holds, and it is a high office in the institution of the judiciary. If we had chosen a different path, we could still achieve the same results. And let it not be seen that we are opposing the war on corruption or that we are defending Justice Mwilu. We are not doing any of those.
But bottom line, the evidence, we are yet, even yourself and other counsel, to know what the DPP has, in as far as to present in court. So this may also be premature to attack the process, and yet they may have a solid case.
We have not attacked we are not saying that the the prosecution should not have happened or any of those things. We are saying that it is possible for you, in order to shield the institution from the damage that has been caused. Because you can imagine what the ordinary Mwananchi is saying about the entire judiciary now, that if somebody who is a second in command in the judiciary is, and Kenyans have already had this case and convicted.
Haven't you called for big wills as we wrap up?
Yeah, I agree with you.
Yeah.
I am just saying, to shield the institution, because the institution will outlive the people who are in the institution.
Okay.
So that the damage that is being done to the image of a judiciary by having a DCJ being actively held before a court is not commensurate to the benefit. Because if we had used another path, get her out of the way first of all as a member of the judiciary through the JSC process, then she can face charges as a raia, as an ordinary Kenyan. Okay. The damage to the institution would have been lesser.
All right.
That's all we are saying.
All right.
Yeah.
Many thanks. Edwin Sifuna is the Secretary General of the Orange Democratic Movement. And so this matter proceeds on Friday, 11 a.m. is when the parties are expected before the Chief Magistrate Linda. There was a prayer made for the suspects not to be present in court, but that was a request that the Chief Magistrate did not entertain, arguing that there were too many requests, and at that particular point, they all resume for session and that seating on Friday. So we'll be following this story. Back to you to hear also the guests in studio what they have to say on this tonight, Linda.
Great, and come Friday we'll cover that for our viewers in a way only we can. Sophia Wanuna there speaking to Edwin Sifuna, who's the ODM Secretary General. He says we will not forgive the DPP if it does not get a conviction in this. And this is a story that I want to break down for you so that you understand what exactly happened in court today. The DCJ did not take a plea. What does that mean? How important is this for her? We'll be doing that with Steve Ogola, who's in studio with us. He's a lawyer. We'll also be speaking to Irungu Kangata, who's a Senator Muranga, but we're speaking to him in his capacity, as a lawyer and the Deputy Chief Whip in the Senate. That in a couple of minutes. Let's take a break. We'll be back.